Oh, I should clarify, and just for the purpose of today's presentation, I will not provide you a full doctrinal explanation of what is public international law. Of course, this is a very complex conceptual debate, but I will focus more on why do we need it for pandemic prevention, preparedness, and response. The type of international law is not the only one, but the one I will be focusing on today is the one uh, that imposes legal rules that apply to states in their relationships with other states. And by states, I mean countries as represented by the public authorities. Often you see international events, conferences, for instance, more recently on climate change, where you see the representatives of governments attending these international meetings, and they're representing a state when they act in these meetings. And in terms of international law, the classic example of uh, the classic example relates to international treaties, which you may know about. And this basically consists of several states agreeing upon uh, a set of rules that will create obligations for them uh, starting from the date in which these treaties enter into force, right? Like national laws. But although here the difference is that these international laws are addressing, states and exceptionally persons, individuals. And why do we need these rules? Well, as it became quite clear with COVID-19 and with previous similar events, pandemics may emerge anywhere in this world. So how do we ensure that, whenever these new events emerge, that public authorities particularly will have a clear idea of how to react to them and what they should do? Because again, this is an issue that affects all of us, all of the states of this planet. So how do we make sure that whenever this happens, that there will be a clear set of rules on what to do and what not to do when responding to these events, and possibly even when trying to prevent these events from occurring? I mean, this sounds ambitious, of course, but this is part of the discussion. Can we really do more than what we are currently doing in preventing these events from happening at all, and in being better prepared for these events before they occur? So this is the core understanding. Again, this is not the end of the doctrinal explanation of what is international law, but for the purposes of today, will be my focus on this type of legal rules. And what we have seen so far uh, during the COVID-19 pandemic is a pandemic response that is sovereignty based, meaning national authorities, right, out of the countries with some limitations, of course, but they have decided on how to respond to COVID-19, including what measures to take, including what data they will share with other states. I'm speaking of public authorities, of course. We know that we as researchers share data with other researchers all the time. But when it comes to public authorities and the data they have, and when they share it with other public authorities, so this is, of course, a different matter. And this is what we saw during COVID-19 is actually the direct result, I would say, of what happened in legal terms, I mean, what happened at the International Health Conference that took place in New York in 1946. In this International Health Conference, among other things, delegates, representatives of states after the Second World War gathered in order to create multiple organizations, among them the World Health Organization. And this was made through a legal act, namely through a constitution, which it's not a constitution like it would be the constitution of several countries, constitution of France or of Mexico or of Italy. It's an international treaty. It's called the Constitution because it constitutes an organization. but it is a legal instrument that also gives this organization a set of powers, and it also allows for creating obligations for states themselves. And this raises the question. I mean, what we have seen indeed is that states were capable of deciding on how to respond to this pandemic, what would be the best public health measure that would be suited to mitigate the spread of the disease. Um, and this, of course, also affected international issues, as I will explain later. But the question is still open. Is it possible to override national sovereignty during public health emergencies? So far, the answer is no, not really. But it's not legally impossible. It's just that there has been no agreement yet on whether to do so and when. So these type of legal responses we have seen, right? The adoption of legal measures across different countries is the result of what happened in this conference, where the delegates said we don't want to give so many powers either to the WHO. We don't want to regulate our responses to such an extent that we will not be able to decide upon our own responses. And this, of course, I'm not saying this in a critical sense. It's just it's a descriptive statement of why we see what we currently see during the COVID-19 pandemic in legal terms. So currently we have international law in the field of pandemic prevention, preparedness, and response. The existing international law we have is centered on the International Health Regulations, which is a legal instrument that was approved at the World Health Organization. But we, as you may see in the news, in media outlets and other settings, we are also witnessing negotiations on a new so-called pandemic treaty. It's a new convention, but it's technically a treaty. And that would mean creating a whole new legal instrument or a whole new legal document that would regulate how states would prepare and respond to pandemics. We will see about prevention because this is the most ambitious part, of course. So in light of these two instruments, one of them already exists, the other one is being negotiated as we speak in Geneva. So how does this work, and what are the existing rules on pandemic prevention, preparedness, and response? The existing law on the field is again focused on the international health regulations, which the purpose of which is to deal with the cross-border spread of disease. And remember, since we're speaking about diseases that either have the potential or actually spread across territorial borders, we need, from a legal perspective, we need the authorities from different countries to act and to do something or not to do something. And this requires coordination because, of course, the authorities of one country, the public authorities of one country, cannot simply order the public authorities of other countries on what to do in the field of public health. And this is why we do need rules that set clear standards and clear indications on what to do and what not to do. And these regulations were approved by the World Health Assembly in 2005, and that's why you see this denomination, and are legally binding for all 194 member states of the WHO. I should add also Liechtenstein and the Holy See, which are not member states of the WHO. But this means their authorities are obliged to follow what's in these international health regulations. And what is the World Health Assembly, right? I'm saying that this was approved at the World Health Assembly. So what is this assembly? So it's the main decision-making body of the WHO. The most important decisions are adopted here. And it's basically, and I'm of course simplifying, it's a yearly meeting of representatives of all member states usually takes place in Geneva, but exceptionally may take place elsewhere. And these delegates that represent every state that is a member of the WHO approve these regulations. So in reality, it's not the WHO as this separate organization, the self-standing organization, that the one that approves these instruments. It's is the delegates of member states themselves. So this also clarifies that we're not speaking about an organization that creates law by itself and then imposes it on states. No, it's states themselves that agree upon these rules, and the place in which they do so is this World Health Assembly through their representatives. And they vote upon these issues, and I can explain, give more details on how this works in practice. But suffice it to say that, this is a lawmaking process conducted by states themselves. It's just that they conduct it in the WHO. And this also will help us visualize who really is creating these rules and for whom. It's states that create these rules for states themselves. And the existing So one of the aspects that is currently regulated under international law, and we can discuss how well it works, but there are currently binding rules on this, binding meaning they are really obliged to follow them, has to do with prompt and reliable information on disease-related events, which have a potential for a cross-border spread. And this has been denominated in the literature as a global public good, right? We all, the public authorities of all countries need such information in order to be better prepared when a disease emerges in another territory and it has the potential to reach one's own country. The public authorities of this country will have a major interest in knowing about these diseases as soon and as accurately as possible. And that's why we need the public authorities of the state in which these diseases emerge to share that information as fast as possible so that the international community can adopt the appropriate measures. And the international health regulations then specify what authorities must notify and when. And I will engage in a few transcriptions because that's what we often do in law. It's a lot of looking at existing texts and interpreting. This is a classic legal tool. And in Article 6 of these regulations, we see how each state party, right, and meaning the authorities of that state, will notify the WHO within 24 hours of assessment of public health information of events which may constitute a public health emergency of international concern within its territory, end of quote. We see here now what states are obliged to do under international law. And namely, that is to notify the WHO and with 24 hours of assessment. I will explain what this means in the following slides. But this is already a function of international law to give clarity on what must be done or what should be done. Otherwise, it would be up to debate and to interpretation and to disagreements on what actually states should do in such a situation. And well, if there's more clarity needed on what exactly must be notified to the WHO, these regulations have an annex which specifies what type of events shall be notified. And there's a description here that states, any event of potential international public health concern, including those of unknown causes or sources and those involving other events or diseases than those listed in the annex. And here, what the annex tries to do, but to a certain extent, we can wonder whether it does so. It includes a decision instrument that authorities can look at in order to assess and to estimate whether they should notify the WHO of the emergence of one of these events. And I won't go into the full details. We can discuss again later what the intricacies of this schematic, of this decision instrument. But what this tries to do is really to give further information to states on what they should notify. And again, this will be useful for other states in order to know whenever there's a disease spreading elsewhere beyond their territories that they should be aware about. And again, I would like to repeat, since they cannot really give orders to the authorities of those other countries where these events emerge, to really give them the information. These rules are meant to give clarity and then, to oblige them to do so under the specifications I just mentioned. And well, I just read this transcription, and it says here within 24 hours of assessment of public health information. So why 24 hours, right? Well, this is considered to be the period. And what does assessment mean? Well, this 24-hour period, what that means is that the 24-hour period does not begin whenever a disease emerges in a territory, but once authorities assess the information. And by assess, it means that they already have at first identified, that there is such an event, which may take varying periods of time depending on the capacity of national authorities to really detect those events. But once they have assessed, right, and assess does not have a very extensive definition in the regulations, but once these authorities have become aware that there is an event that should be notified to WHO, they have 24 hours to do so. It's not a complicated procedure. It's simply, can be at times even sending an email or, using a so-called event information site that the WHO has, where the authorized users can enter the system and pour in the data that they want to transmit to the WHO. And the details may vary depending on how much data they do have. But the reasons why this period begins only after assessment has been made and not before, right? And then we can wonder, why doesn't this 24-hour period begin immediately once a disease emerges? That would be unrealistic, and it would not be feasible under the current state of the art of disease surveillance, right? Among other things, because even in high-income countries with robust healthcare systems and robust surveillance systems, it may take some time until a novel, quote unquote, novel disease that was previously not circulating in a routine fashion in a community is identified. This happens also in high-income countries, so it would be unrealistic to expect the authorities to fulfill an obligation they simply don't have the capacity to fulfill. And that's why this 24-hour period was set to begin once authorities have assessed the information related to such an event. The other reason, of course, consists of the varying capacities. This is also a factor, right? Although some authorities, the public health authorities of some countries may be able to detect these events from emerging sooner than others, this would, of course, be disadvantageous. An obligation to report sooner might be disadvantageous to those other countries where the capacities are simply not in place to detect these events sooner. So this is what the rules say on what type of information should be notified to the WHO. And this leads to the, this is one set of obligations that we have under the international health regulations. But this obligation should be read and understood in comparison to another obligation, namely, and this is established in Article 43, that states must refrain from imposing measures related to international travel and trade that are more restrictive than necessary. I'm summarizing this article. Excuse me. And what this tries to do is to provide an incentive for states to be transparent and forthcoming regarding their notifications. Because if we look at if we think of what may happen once public authorities share that information with the WHO and therefore with the other states, with the international community, the other states might react in a certain manner that might affect them negatively, particularly, by imposing restrictions on international travel and trade in order to really isolate that other state internationally, leading to a very negative impact on the economy and on persons as well. And this is what these regulations try to balance, right? On the one hand, we need that information. On the other hand, we try to incentivize states to provide that information by ensuring that, there will be no disproportionate reactions. For instance, on the 30th of January of 2020, when the World Health Organization declared that the spread of the SARS-CoV-2 virus was a public health emergency of international concern, it recommended states not to impose any travel or trade restrictions. And of course, the recommendation was not followed in a widespread fashion. But, it is believed that the reason behind this recommendation was indeed the attempt to strike a balance between, okay, on the one hand, incentivizing back then, remember it was mostly in China where this disease was spreading, and China had notified, right, the WHO. So the goal was to incentivize indeed this notification and to provide assurances that there will be no disproportionate responses. But of course, this was before there was any evidence on whether these travel or trade restrictions were effective at all in mitigating the spread of the disease across borders. And this evidence is still, coming in, and we know that it's quite complex. So this is not really a monocausal link between the imposition of these measures and in a particular health outcome, because there are multiple other measures in place, and it's not always possible to isolate really the effectiveness of these measures. But nevertheless, it was later, the World Health Organization later had to revise its recommendation and say, well, indeed, travel restrictions may be effective in particular circumstances, but what's legally relevant is the realization that such balance should be struck somehow, because otherwise states might not have the incentives to share that information transparently and promptly. And in fact, to this day, there are disagreements among legal scholars, including myself, on how this obligation should be interpreted. Basically, focus around the question, are these travel restrictions that we have seen during COVID-19 legal or not under international law? Yes, well, some colleagues consider that no, they're not legal and they're actually violating international law. And what we have seen is, of course, the dereliction of obligations by states. But we see another, side of this debate with some scholars stating, yes, they are legal and there's evidence of their effectiveness. So why shouldn't they be if they have shown not to be actually disproportionate? I must say that personally, but this is again just my opinion, I lean more towards the latter, right? I also consider that they're not actually illegal, but nevertheless, this leaves open the main challenge of determining, well, how do we incentivize then states to be forthcoming with their information? I don't mean to say that this debate has been settled, but this is, again, to show you what the current legal debates are about and what will currently continue to be debated in Geneva, where legal reforms are taking place. And, well, now we have seen the balance that the international health regulations try to achieve between, on the one hand, the need to ensure states that they can share that information without fearing, the reactions of other states. And on the other hand, the need to allow for those other states to take the measures that they do consider to be appropriate to facing these threats. So although we can still wonder to what extent this balance has been achieved, we do have currently a surveillance system thanks to these obligations, which the WHO conducts. Insofar as the notifications under these international health regulations do take place routinely, this is not just related to emergencies or pandemics like COVID-19 or the different Ebola outbreaks that we have seen recently, or other events like the H1N1 influenza pandemic. We also have, I'm going to move this here, we have a constantly operating surveillance system. And if we look at the time frame before COVID-19 emerged in December 2019, we see that were literally hundreds of events reported yearly to the WHO, and these are most of them are related, to communicable disease events among persons. We had a grand total until, again, December 2019. I didn't include the data after COVID-19 emerged because most of the events were related to COVID-19 after that, but we had a grand total until December of 2019 of 4,205 events. And luckily for all of us, of course, not all of these events, as we know from disease surveillance, will lead to a catastrophic outbreak. But it's really important that we know about as many of them as we can, because that's the point of the international health regulations. We should be informed as early as possible, just in case, particularly in case one of these events evolves to become either, the H1N1 influenza pandemic, which was reported in this time frame, the West African Ebola outbreak, which was reported in the time frame in 2014, or in December 2019, when the COVID-19 pandemic, the SARS-CoV-2 virus was first identified, or at least was assessed, right, in China, in Wuhan. So this does tell us that there is currently an invisible surveillance system. Why do I call it invisible? Well, I show you the number of events, but what we do not know, what's not publicly available, is are the details that are related to every event. Namely, okay, what disease was it? Where exactly did it emerge? How many people were infected? This information is not publicly available. It's available for authorities, right? Public authorities that have access to the WHO's database, this event information site, but it's not available to the public at large. Sorry, my video keeps moving. And why is that? This is not a coincidence, this is not an accident. This information is not publicly available because it's meant to also incentivize states to be forthcoming. Maybe the public authorities don't want all of this information to be publicly available in order not to spread panic, or in order to prevent, disproportionate reactions. And because as we look at, the weekly epidemiological record of the WHO, for example, just before these regulations entered into force and became, mandatory for all states, we did have information regarding these events, particularly under previous iterations of these regulations. We could see, right, that there was a cholera outbreak, for example, or cases of cholera in Guinea and Sudan, in Canada, or in Australia. And we saw, the cases and deaths. And this was the last weekly epidemiological record before these regulations came into force. And the first one after they came into force no longer had a section on these disease notifications. And this, again, was an active decision in order to really incentivize states, public authorities, to be transparent and say, well, do not fear of the consequences. There will be, eventually we can see how there still are consequences for these notifications. But of course, this shift from a publication at the weekly epidemiological record to a more, let's say, confidential handling of this information had a reason behind it. And currently what we see is some proposals, excuse me, to amend, to reform these regulations. And the goal is to look beyond COVID-19, looking at time. We have 14 different proposals. I will not go through all of them, but suffice it to say that they try to strike this balance, right, in providing incentives for sharing such data with the WHO, which can then transmit it to the other states. And there's a deadline for these proposals of 2024. So please stay tuned. We will see in the coming weeks or months what these proposals actually want to do with regards to the surveillance system and with regards to the the possibility of adopting particular measures that restrict international travel and trade. And these proposals are not publicly available yet, but they should become publicly available in the coming weeks. So we'll, of course, keep an eye on those. But so why would amendments be relevant, and why is this balance relevant, particularly in current practice? And I'm taking that you are aware of the recent creation of a so-called pandemic hub, WHO hub for pandemic and epidemic intelligence in Berlin, of all places. It will be here. The new building is currently located or hosted by the Charité. And the operations of this hub will be directly dependent on whether public authorities from those other territories and researchers as well, of course, I'm assuming it won't be only public authorities, but to what extent will they be willing to share that information? It's not a coincidence, indeed, that the current director of the pandemic hub, Chikwe Ihekweatsu, mentioned that, excuse me, the main challenge will be political. How to ensure really that this data flows into the hub is technically it's quite feasible, but politically it's really where the challenge lies. And this is when international law can play a role in really allowing and putting in place all those incentives that authorities will need to really engage in this data sharing. And so again, we see how the proper regulation of these issues will have practical relevance, particularly at least for the operations of this pandemic hub in Berlin. And so, okay, so far I've spoken about international law and obligations, mandatory rules. So what happens in case there's non-compliance? Let's say public authorities do not comply either because they can't or because they don't want to. They have other reasons not to comply with those obligations I just mentioned, either those of excuse me, of sharing the information related to those events, or those related to the need not to react disproportionately. So what happens then? We're speaking about law, right? There should be consequences for breaching law. Yes, but keep in mind, international law does not have the same type of effectiveness that national law, the same type of mechanisms to ensure the compliance that national law. There's no, it's difficult to think of an international police, and there are international courts that can indeed enforce the compliance of these obligations. But unlike what happens with national law, where if we break national law, if we breach a national law, we might incur in sanctions. But in case the state does not fulfill its obligations under these regulations, the WHO is not empowered to impose those sanctions. It's not designed to be such an organization that would punish states whenever they don't fulfill their obligations. It can nevertheless engage in naming and shaming, as it's called. There's a concept in international law known as reputational cost, meaning, well, if a state does not comply, we point out to it so that there may be some other types of consequences. It has done so in the past. The WHO has criticized particular governments whenever they refuse to share information that they need in order really to communicate to the other states what's happening. And remember, of course, that the WHO is in an ideal, or at least in a privileged position, to be the liaison with those other states. And that's the most it can do, right? Legally speaking. But that's not the end of it. So in case, a state does not comply with these obligations, might be multiple reasons. There might be the possibility to resort to a court, right, an international tribunal, either because a state does not share information promptly and transparently, or because the other state reacts disproportionately whenever that information is shared. But no such judicial proceeding has ever taken place. This type of these type of obligations have never been at the center of a judicial case internationally. I mean, it came close once. So these regulations, I mean, different versions of these regulations have existed since 1951. Excuse me. And there was almost a judicial proceeding under these regulations where states this almost went to an international court to settle their differences, which is what ideally happens in international law whenever there's a disagreement, right? Currently, we see other examples of states using force whenever they want to settle disagreements. This is one thing we want to avoid. But in 1970, excuse me, Turkey reported a cholera outbreak in its territory to the WHO. And again, in a previous version of the regulations. And the consequence of reporting that cholera outbreak was that other states, namely, I mean, this is publicly available information, decided to restrict travel to the reporting country, to Turkey. Bulgaria and Romania, the government said we do not want to be affected by this cholera outbreak. We want to they close their borders with Turkey, or all entry of transit from Turkey. And you can imagine this led to considerable economic damage, and to many, of course, to affecting individuals as well. Excuse me. So the government of Turkey decided to launch consultations at WHO, trying to settle issues. It never made it to a court because governments can also agree, well, that we don't need to go to litigation, which can be expensive. So let's settle this amicably. Let's settle this in a friendly manner through diplomatic offices. End of the story. But so this was the one time there was almost a case at an international court where the states would settle their differences. Before the COVID-19 pandemic, there had never been any attempts whatsoever at bringing another state to an international court for failure to notify the WHO timely and transparently. This happened as previously. I could go more into details in the discussion, but this had never been considered. It was always through goodwill and through the spirit of cooperation and coordination. And it was not, these regulations had not been understood as meant to punish states whenever they do not comply with their obligations. No, to the contrary, they're meant to be fostering coordination. So this shows you that this is really the COVID-19 pandemic brought a change in this mentality, if you want to deem it that this is really might even lead to a sanction, right, or a consequence, or a legal consequence. Now, so far, I've spoken about the regulations. This is the current instrument we have that is currently in force. It has obligations for states, 196 states. But there's another process ongoing. Do my best to be brief. You may have seen as well in news reports that there is a current so-called pandemic treaty being negotiated. And there's, of course, there are high stakes involved in this process. The formal denomination might be a new convention on preparedness, prevention, preparedness, and response. I left prevention out because this is being debated. So what would the purpose be? Since the 1st of December of last year, the World Health Assembly, again, this meeting where delegates of states gather and vote upon important issues, approved a decision to establish a so-called intergovernmental negotiating body. This is the body that is currently tasked with conducting the debates between delegates. What will they agree upon? What type of rules will we have in a new treaty, right, that will be operating in parallel to the regulations? This is the decision. And the main goal is to regulate areas that these regulations I've spoken about so far currently do not regulate. I will address some examples in the next slides, but you will see that the two chairs of this intergovernmental negotiating body are Roland Dries from the Netherlands and Precious Matsoso from South Africa, both from their respective ministries of health. And this was made on purpose, right? The goal was to have to keep in mind the global north and the global south in these negotiations, so they could both have an equal footing and an equal voice in this process, this political process. So this, again, is no coincidence. It was carefully designed this way so that we can have representativeness in this body. And, excuse me, in November 2022, a few weeks ago, 2 weeks ago, if I remember correctly, a so-called conceptual zero draft of this pandemic treaty was published. And what does this conceptual zero draft have? It does not yet have the wording that will be part of a future treaty. This is not the text that we will already see in a future treaty. It has some overarching issues that will be the basis for negotiations. So remember, delegates still need to negotiate on what they're willing to accept, what they're not willing to accept. They still haven't accepted any texts whatsoever that will later lead to obligations for them in the future. I will focus today on three briefly before I conclude: sovereignty, equity and solidarity, and One Health. How does this conceptual zero draft deal with these issues? But going back to the point on sovereignty, which means that, the authorities of a state have the right and the power to really decide upon the issues that pertain to their territory, right? They can decide on a range of issues. And under this conceptual zero draft, state parties will retain the sovereign right to determine and manage their approach to public health, notably pandemic prevention, preparedness, response, and recovery as well. But there's still no clarity on how that will work, of health systems pursuant to their own policies and legislation. What this means, and the message that states wanted to send regarding this treaty, is that the following policies or lack thereof would not be regulated by a future treaty. For instance, a laissez-faire approach towards pandemic response, where we have seen protests in Brazil, among other countries, whenever public authorities decide not to act because they think the public health measures are too onerous, and so they choose to really not to intervene in the face of a pandemic. And we have another extreme, as we see currently, and you may see this in the new media often, the zero COVID policy that is currently being in place in the People's Republic of China. These issues of choosing the appropriate public health response will fall outside of the treaties. This will still remain with national authorities to decide whether and when to adopt or not to adopt measures of a particular kind when responding to a pandemic. There might be some limitations, but I can gladly discuss them in the Q&A. And then we have equity and solidarity, right? The very normatively charged concepts, excuse me, which is focused on a fair distribution of medical countermeasures, not just pharmaceutical products. Again, this covers also diagnostic and therapeutics. And that here, equity is defined as fair, equitable, it's tautologic, I know, timely access to affordable, safe, and efficacious pandemic response products among and within countries, including between groups of people, irrespective of social or economic status, end of quote. And this, of course, is the insistence on having this issue in a treaty is after what we have seen with so-called vaccine nationalism, where the global distribution of COVID-19 vaccines in particular, but now not exclusively, has been, let's say, far from being equitable. This also includes, of course, other medical products like personal protective equipment or testing kits, excuse me, diagnostic kits. So how far could a treaty go? And I'm aware we have a short on time, so I'll have to stroll through to give way to questions and answers. We don't know how far this equity model and a treaty would go in regulating really the entire process of developing new medical countermeasures, particularly, right? This is the concern that whenever there are new and also existed, but new medical countermeasures, that they become accessible to all the countries that need it. But how can this be done, right? Legally speaking, we have the challenge that, excuse me, but I have to oversimplify, that the current process of developing new medical countermeasures for facing pandemics, if in case there aren't existing ones, has to do with a complex process. Again, this graph does not do any justice to the complexities involved in developing, right, in R&D of these medical countermeasures. But if we have, one main concern that emerged during the pandemic is if we have public funding here involved in the development of these medical countermeasures, shouldn't we envisage further conditions on which that will determine access at the point of care, particularly to those medical countermeasures? We have legal issues such as, grant agreements. What conditions do they foresee for whenever, if and when, excuse me, a candidate a medical countermeasures candidate is successful? And of course, we eventually, once a product is ready in the market, we can think of public procurement procedures. The point I made here is what this graph is that what happens here, legally speaking, already at the early stages of medical countermeasure R&D, will determine access from a legal point of view. And this raises the question, if we're speaking about equity in a treaty, one open legal challenge is how deep will that treaty go in changing these practices at the national level? We do not know, and it would be a very ambitious idea because it's unprecedented, right? That a treaty can regulate how, for example, these grant agreements or contracts, or even these public procurement contracts are conducted, which are the ones that set the conditions for access to those medical countermeasures by public authorities that want to deliver them at the point of care. Private institutions can, of course, also engage in these contracts, but the concern is for public authorities to also have access to those medical countermeasures. And we also have solidarity, which is currently defined as the national, international, multilateral, bilateral, multilateral collaboration, coordination, and cooperation, sorry for the long transcription, in order to achieve a fairer, more equitable, and better prepared world. It goes back to equity. But there's one article which goes back to what I was referring to in the regulations. It refers to promoting solidarity with countries that report public health emergencies as an incentive. So this is a novel idea of solidarity, and it keeps in mind what has happened during the COVID-19 pandemic, particularly what we saw when the Omicron variant was reported, officially notified by the government of South Africa to the WHO in compliance with the international health regulations, and the results thereof was that it was subjected to a number of travel restrictions that had a major impact in its economy. So we can wonder what are really the incentives for being transparent if what the result will be that the reporting states will then be subjected to such measures. This is what is trying to be addressed here, but we'll see how far they go in doing so. And finally, with regards to One Health, I'll keep it very brief. The principle of One Health in this conceptual zero draft is a coherent, integrated, and unified approach aiming to sustainably balance and optimize the health of people, animals, and ecosystems. And Article 10 focuses One Health and on the need to build and reinforce surveillance systems, including One Health. So what could we see here? What would be the potential of a One Health approach towards surveillance systems through international law? Well, currently, the international health regulations that I spoke about, and this is GAP, are activated, so to say, and focus on these novel diseases once there is human-to-human transmission. But a new pandemic treaty, right, which is something the regulations do not do so far, might help in increasing surveillance in an earlier stage, so that we can have earlier warning systems than the ones we currently have, the ones I just showed you. This is how One Health has so far been operationalized. It remains to be seen whether there will be other implications towards the One Health principle. To conclude, uh, we, in the case of these reforms, so the challenge for those negotiating and drafting the text will be to think of future events that might look quite differently than COVID-19, while keeping in mind what has happened, of course, during the COVID-19 pandemic. We cannot ignore the lessons. We should not ignore the lessons we have learned so far. And of course, we can discuss what these lessons were manifold. But of course, we should also keep in mind that future pandemics might evolve quite differently. So how can we have rules that clearly establish what states should do in such an open manner, in such a broad manner, so that we're better prepared for the future? This is not a small challenge, and it's of course part of legal research to come up with the best possible formulation of such rules that can enable a better pandemic prevention, preparedness, response, and recovery, ambitious as it may sound. And we have to, of course, be humble and realize that we must deal with the limitations that we currently have, right, in this current stage of knowledge. But nevertheless, this is the task we have ahead of us, and I will be more than happy to discuss these issues further with you. Thank you very much for your attention, and very happy to join you today again.